Hello, everyone, and welcome to today's live broadcast. It's fabulous to be here with you. Now, as I like to do, I like to bring you little tips which have come from my own experiences of what I am working with clients on or dealing with in my own experience of living in strata. And I have a tip for you today, and that is about what we should be doing when we receive tribunal applications. So when we as buildings or as committee members or as strata managers are notified by the tribunal that someone in the building has filed an application with the tribunal, and we have received notice of that. And we might not be receiving notice because we are the respondents to the application. It could just be that a owner in the building has filed an application naming another owner, and it is the responsibility of the tribunal to notify the building, the owners corporation, of any application that involves the building. So that's why, as a manager, as an owners corporation, you might be getting copies of applications that don't actually name you, the building, as a party, but you do get the copy of that application, and you do need to do something about that. So that's what I wanted to chat with you about today. Now, I am going to give you a little disclaimer. I am sitting in the common area of my office, and if we have coffee machines, if we have microwaves, it's because it's that time of the day and a few people walking past who might just say hi. So that could be fun. Now, what I want you to do if you receive an application for a tribunal order is to go over and have a look at Section 228 of the Strata Schemes Management Act in New South Wales. And that is the section that says the registrar has to give notice to anyone who would be affected by an application, and they must do that by giving a copy of the application to that person. So that's where that part comes in about the building is going to get notified even if it's not actually a party to the proceedings. And on receipt of that application, the owners corporation must immediately cause a copy of the application to be prominently displayed on the notice board, if there is a notice board maintained under the bylaws, or on some part of the common property. And the owners corporation must continue to display that notice for the period specified in the notice for the making of submissions. Now, what does that mean? Sometimes we get notices from the tribunal that say to us, you have 7 days to make a submission in relation to what it is that this lot owner, for example, might be asking. But tribunal notices don't always say that. In my experience, a lot of them simply say, turn up at the tribunal on this date at this time. And there's no period specifying, a little bit unusual there in our legislation, which might need a change on review. I think the intention when the new act came in was that when notices came from the tribunal, they would set a time period for the filing of submissions. But for whatever reason, that's not actually happening. What's happening is that the parties are actually being called up straight away to the tribunal, and the tribunal is then making directions about the filing of submissions. So it's a little bit unusual when it comes to looking there at Section 228 and the period that we're supposed to display this application. So what I would do is display the application for a period until the first directions hearing, or if there is an actual hearing set down, until the hearing has taken place, that first appearance before the tribunal. The idea, of course, being to make sure that anyone who wants to have a say is aware of what's happening, that this event is happening before the tribunal, and they can turn up and they can have their say if they like. Now, a question I was talking to a strata manager about today, very practical question, Amanda. Sometimes we get applications that are about 300 pages. We have a very excited lot owner who wants to say a lot of things to the tribunal, and the application is very lengthy. Now, of course, we cannot put 300 pages up on our notice board or on a part of our common property. and the legislature does not expect you to do that. So when the application is lengthy, and generally if it's more than 2 or 3 pages, you're going to have trouble finding a place to put it up. So what I recommend is that you put up the notice, the front page notice. It's usually called a notice of order or a notice of directions hearing or a notice of hearing that the tribunal has sent out. Put that one notice up on the notice board, and then owners who are going past the notice board are going to see that it is there, and they're going to know that that application has been filed, and they can contact the strata manager or the committee if they want more information about that application. Now, if it's an application where the owners corporation is named as a respondent or a party to the proceedings, then you're going to be talking about this application in your committee meetings. If you've got a general meeting coming up and you're considering engaging lawyers, there's going to be a motion on the agenda about that. So owners are going to know that these proceedings are being discussed because they're mentioned in minutes of committee meetings, in agendas, in minutes of general meetings. So that's also an important reminder to make sure that you are following those procedures and you are telling owners about the application and about what's going on with that application. And that's really what I think the legislation is designed to do. It's to make sure that you're keeping other owners informed about what's going on in the building when there's litigation going on. So always think about, sure, I can't put the entire application up onto the notice board because it just won't fit, but am I, through other methods, making sure that this message about these proceedings is getting out to owners? So it might be mentioned in a newsletter that you send out. As I said, it might be mentioned in your committee meeting minutes. And of course, as we know from our other videos, a video a couple of weeks ago about committee meeting minutes, we must be sending those minutes out to all owners if we are in a small scheme, so less than 100 lots. 100 lots or less is actually what it is, not less than 100 lots, less than 101 lots. We must be sending our committee meeting minutes out to all owners. So they're going to know what is going on in the building specific to this litigation if that is being discussed in your meetings. So that is your tip for today, all about what to do if you receive a tribunal application. Okay, so feel free to come back and check out those steps. Section 228 of the Strata Schemes Management Act is the place to go to find out what needs to happen. Often overlooked, I think, by strata managers, so don't forget that it's there. We do need to be putting those notices up on our notice board, and don't panic when you receive an application in the tribunal. That is my closing advice. Don't panic. There are steps to be taken. There are always places to get advice, people to talk to who can walk you through, hold your hand through that process. So I'd love to hear about your experiences if you have been involved in tribunal proceedings, if you've received an application that relates to proceedings in the tribunal. What have you done? Have you followed these Section 228 steps? What has stopped you perhaps from following those Section 228 steps? What haven't I thought of there that might get in your way? Please feel free to share that in the comments section, and I will catch you all next time.